Welcome to MOOC on Human Rights in India. Over the course of this module and the coming module, we will look at the rights of persons with disabilities and the institutional framework for protecting their rights. In this module, there are two objectives. One, we seek to understand the legislative framework for the protection of the rights of persons with disabilities, and secondly, what are the international standards which seek to protect the rights of persons with disabilities. If you see, in general, one finds that the persons with disabilities face discrimination, exclusion, marginalization, as a result of which they are unable to enjoy all human rights on par with others. There exist serious physical, mental, environmental, attitudinal, cultural barriers to the effective participation of persons with disabilities in all walks of life, as a result of which they become relegated to as a second-class citizens, unable to enjoy the full gamut of human rights. This is a very serious human rights issue indeed. In fact, the persons with disabilities have organized themselves and their families have organized, and the NGOs, the civil society movement, have put pressure and have been responsible for changes in the legal framework and evolution of a series of standards at the international level. And today we find that there is a paradigm shift from a welfare-based approach to a human rights-based approach to the problems faced by persons with disabilities. Now, let us turn our attention to the constitutional safeguards or the legislative safeguards for the persons with disabilities in India. Article 14 of the Constitution talks about right to equality and equal protection of laws. Article 15 and 16 prohibit discrimination based on sex, race, caste, religion, or place of birth, or any of them. And if you look at the directive principles of state policy, Article 41 talks about the special efforts to be taken by the state to secure right to work, right to education, in case of unemployment, in case of persons with old age, persons who are sick, and in case of disablement. So we find that the word disabled does not figure in the part 3 of the Constitution dealing with fundamental rights, but in the directive principles of state policy, it figures that states shall take special measures in cases of disablement, subject of course to the limits of economic capacity, subject of course to the limits of development of the state. When the Constitution was drafted, there was a recognition of the social disability on account of discrimination suffered by persons belonging to scheduled caste, particularly in their access to temples, in their access to bathing ghats, drinking water, and other public places. But there was no recognition, no proper appreciation of the plight of the persons with disabilities. But the Indian courts had been at the forefront of an expansive interpretation of judicial interpretation of various rights in the Constitution of India. In Nandakumar Narayana Rao Godmare versus State of Maharashtra, the Supreme Court ordered that a candidate who was rejected from employment on the grounds that he is a colorblind person was set aside, and the court ordered that he should be employed in one of the posts. In fact, there were 35 posts for which 5 alone required a perfect vision, and the Supreme Court said the remaining 30 posts which do not really require perfect vision, he should be appointed. So it was quite a progressive interpretation by the apex court. The 1995 Persons with Disabilities Act was enacted after a lot of struggle by the persons with disabilities and their organizations. In fact, this item figures in the state list, but there was a proclamation at the international level about a decade for persons with disabilities, and this observance at the international level and this international declaration enabled the government of India to bring in a legislation called Persons with Disabilities, and the full title of the act goes like this, and it talks about equal opportunities, protection of rights, and full participation act. In fact, the objectives of this legislation are twofold: to enable the persons with disabilities to enjoy many rights on an equal basis with others, particularly the social and economic rights, and also their full participation in various activities of the society. The Persons with Disabilities Act identifies 7 types of disabilities, and the model adopted here is one of a medical model and not the social perception of disabilities. And there are several chapters in the Persons with Disabilities Act which deal with non-discrimination, which deal with affirmative action, which deal with right to education, employment, and prevention and early detection, and also persons with severe disabilities. Persons with Disabilities Act 1995 was an important advance as it sought to protect the rights of persons with disabilities. It had a focus on the rights, yet a number of critics say that it provided government with many escape routes, as it limited the enjoyment of many provisions to the economic capacity of the state or the development of the state. And the presence of prevention and early detection chapter in the Persons with Disabilities was also not liked by the disabled activists. Now, this act was replaced with a much more modern act in 2016. It's called Rights of Persons with Disabilities Act 2016. It was introduced in the Parliament in 2014, and after due deliberation, after due legislative process, it was adopted. Before we go to the Rights of Persons with Disabilities Act, it's very important to see the international context. In fact, at the international level too, there had been many attempts at the UN General Assembly, which started with several non-binding declarations or standards. For instance, there were declarations dealing with rights of disabled persons or rights of mentally ill persons, and these number of declarations dealing with several categories of disabled persons eventually led to the adoption of a UN Convention on the Rights of Persons with Disabilities in the year 2006. India signed and ratified the UN Convention on the Rights of Persons with Disabilities. Of course, India did not sign the optional protocol to the Convention on the Rights of Persons with Disabilities. Here, this convention again marked a big shift in the way disability was perceived, in the way disability was understood. It focused not so much on the physical or a impairment per se, but it looked at the social and other barriers which prevented on the full enjoyment of rights on par with others. So here is a very interesting and very different definition of disability that has been brought in by the UN Convention on the Rights of Persons with Disabilities, which has in turn inspired developments at the national level also. As India signed and ratified the UN Convention on the Rights of Persons with Disabilities, there was a need for Indian government to harmonize the current legislations with the requirements of the UN Convention, and that in that process Rights of Persons with Disabilities was adopted in the year 2016. Dear students, we were trying to unravel the legal framework for the protection of the rights of persons with disabilities. We examined the constitutional provisions. We also saw the provisions in the Persons with Disabilities Act of 1995. Now let us take up the Rights of Persons with Disabilities Act of 2016. In fact, as you know, India ratified the UN Convention on the Rights of Persons with Disabilities in the year 2007, which required that all existing laws must be harmonized with the requirements of the UN Convention on the Rights of Persons with Disabilities, and that's how this new act was enacted in the year 2016 and to replace the 1995 Act. Here, the number of disabilities have been increased from 7 to 21. They also include currently things like thalassemia, hemophilia, acid attacks, and disability arising from muscular dystrophy, intellectual or learning disabilities, and Parkinson's disease. So it's a very good this thing. Earlier in 1995 Act, these 7 disabilities included the locomotor or orthopedically challenged, visual challenge, and hearing challenge and such. And these have been expanded significantly and to 21. In fact, in the Rights of Persons with Disabilities Act of 2016, if you look at the section 2, there are several definitions given there, and a barrier has been defined as any hurdle, any let's say cultural, social, physical and other hurdle which affects the ability of a person with disability from enjoying rights on par with other human beings. So the barrier has been defined, and discrimination term also has been defined under section 2 as to include any distinction, restriction which affects the enjoyment of a full range of human rights, civil, political, economic, social, cultural, of a person with disability on par with others. Section 2 further defines a person with disability as one who has a physical, hearing, visual or sensory impairment which in conjunction with the barriers affects the full participation of a person with disability on par with the others. And now this definition in the 2016 Act takes inspiration from the UN Convention. Here the focus is not so much on the impairment per se, the focus is on the impairment and its conjunction with the barriers which affect the full participation of a person with disability in all walks of life. And so the reason is that there should be full participation of persons with disabilities in all walks of life. Now, if you look at section 32 of the Rights of Persons with Disabilities Act of 2016, it seeks to reserve not less than 5% of seats in higher educational institutions, government higher educational institutions are funded by the government, and these 5% includes 1%, and this 5% includes though for those with the benchmark disabilities. Section 34 of the Rights of Persons with Disabilities Act further reserves 4% of jobs in government sector, out of which 1% shall be for those with blindness or low vision, and 1% shall be for locomotor disabilities, which include cerebral palsy, which include muscular dystrophy, acid attacks, dwarfism, and 1% for hearing impaired or deaf. Out of this 4% reservation for jobs in the government sector, 1% is to be reserved for those belonging to autism, mental illness, intellectual disability or multiple disabilities. So 2016 Act, which seeks to give effect to the provisions of the UN Convention on the Rights of Persons with Disabilities, is an important advance in the legislative framework. Now let us look at other legislations dealing with the rights of persons with disabilities. We have a national trust for welfare of persons affected by autism, cerebral palsy, mental retardation, and multiple disabilities of 1999. This act arose from the demands of family members for an effective arrangement of guardianship. In fact, this National Trust Act provides for the appointment of local level committees and also has elaborate provisions for the appointment of guardians and their functions. Mental Health Act 2017 is yet another important legislation. It seeks to amend, modify the Mental Health Act of 1987 and also harmonize the mental health legislation with the requirements of the UN Convention on the Rights of Persons with Disabilities that was adopted in the year or ratified in the year 2007. This Mental Health Act of 2017 defines mental illness and also tries to provide for the treatment, care of mentally ill persons. It decriminalizes suicide and says that a person who has attempted to commit suicide shall be given proper treatment and care so that he can be rehabilitated, and he should not be punished for the attempt to commit suicide. And it recognizes that person as a person who has undergone stress and as a person who requires treatment. Chapter 5 of the Mental Health Act of 2017 outlines the rights of persons with disabilities, and in particular right to access mental health care, mental health services in institutions run by government, in hospitals run by government, and also it also specifies the quality of such treatment, and that should be affordable, and it should be of a particular quality, and it should be made available to all, including those who are below the poverty line. If you look at the persons with mental illness, they suffer from stigmatization. The moment a person is branded as a mentally ill person, society tends to discriminate them and the members of their families, and that's why the confidentiality is an extremely critical for persons with disabilities. And the Mental Health Act therefore has provisions to ensure that the information relating to the treatment, either mental health treatment or physical treatment taken by persons with mental illness, shall not be disclosed, or their photographs shall not be released through the media without the consent of the persons who are affected. Now, Section 5 also has a provision for an advance directive by a person who is affected by mental illness, in that person who is not a minor can specify the manner in which he or she can be treated, and in collaboration with a mental health board, and this directive has to be supported by an authorized medical doctor and the authorized mental health board. Let us see the way a mentally ill person is treated. Oftentimes, electro-convulsive therapy or ECT is administered to mentally ill person with a view to cure them. The Mental Health Act of 2017 prescribes that no electro-convulsive therapy shall be used on minors, and for others, whenever it has to be used, it shall be used along with muscle relaxants and after administering anesthesia. The Mental Health Act of 2017 also says that these persons shall not be held in a solitary environment or in seclusion, or they shall not be restraint shall not be used them unless they are absolutely necessary. There was one case which went to the Supreme Court of India, that was by the Sheila Barse. She drew the attention of the court to the plight of the non-criminal mentally ill persons who were often held in jails, and the Supreme Court held that this practice is totally unconstitutional and illegal. So no non-criminal mentally ill persons can be held in jails. And if you look at the practice, though the Mental Health Act says that the persons with mental illness shall not be held in restraints unless it is absolutely necessary, there was a massive fire tragedy in Eravadi in Tamil Nadu, where 26 mentally ill persons who were chained to their beds died in a fire tragedy. And in wake of that, the National Human Rights Commission asked all the state governments to certify that no mentally ill persons are chained to their beds or held in such conditions. There's a Rehabilitation Council of India Act of 1996 which seeks to regulate the way special education programs, the way training programs and other programs for rehabilitation of persons with disabilities can be conducted. We have seen a number of legislations for the rights of persons with disabilities. They have been complemented by policies at the central level and the state level as well. If you look at the central level, there is a disability policy, there is a national policy on mental health, and in addition to these legislative safeguards and constitutional safeguards, there are other safeguards at the international level which are of two types. There is a non-binding standards by way of declarations, by way of the UN General Assembly itself has adopted a number of declarations for the mentally retarded persons or for persons with disability or mental illness. And there was a Biwako Millennium Framework, there's a UN Decade or Asia Pacific Decade, and there's a World Program of Action. All of them constitute non-binding standards which are supposed to guide the conduct of the states. And as far as some binding standards are concerned, there is this UN Convention on the Rights of Persons with Disabilities that was adopted by the UN General Assembly in the year 2006 and which of course India ratified in the year 2007. In conclusion, we have covered the provisions in the domestic legislations as well as the international norms for protecting the rights of persons with disabilities. What is required in practice is a strict implementation, scrupulous adherence to these provisions, and they need to be viewed as bearers of rights, not as objects of charity or pity. Thank you. See you in the next module.